Welcome to The Source, where we combine the headlines with in-depth conversations with the newsmakers themselves. Today on the program. Once again, Bureau of Corrections Chief Nicanor Faeldon is on the hot seat.
Let justice be served here. Because at the end of the day, if we will not serve justice here, then we cannot sleep.
As questions linger on the implementation of the Good Conduct Time Allowance law.
By his own admission, sinabi na rin ni Director Faeldon na 11,000 yung naka-line up na i-release. Baka naman parang container, per container 5,000 or 10,000. Baka naman per released convict, baka naman meron din corresponding amount.
Lawmakers raising concerns on the release of high-profile inmates and corruption allegations.
Now, whether that will apply to heinous, to convicts of heinous crimes is not something that we can cover in that decision yet. It's up to the Secretary of Justice to tell us kung ano yung kanyang sinasakop.
With some calling for the abolition of the GCTA law. House Committee Chair on Constitutional Amendments and author of the GCTA law, Congressman Rufus Rodriguez, joins us live. Thank you for joining us. Sitting in for Pinky Web, I'm Ina Andolong. Lawmakers scrutinizing the provisions of Republic Act 10592 or the Good Conduct Time Allowance law, following the controversy hounding its implementation and the supposed release of high-profile inmates or convicts. The Justice Department suspends the review of all qualified inmates under the GCTA law. Even President Rodrigo Duterte weighs in on the possible release of rape-slay convict Antonio Sanchez. How will lawmakers resolve the conflict in the law? Is an amendment enough, or should Congress move to abolish it? Let's go straight to the source of the story. House Committee Chairman on Constitutional Amendments and author of the Good Conduct Time Allowance law, Congressman Rufus Rodriguez. Sir, good morning.
Good morning, Ina. Good morning to your viewers of The Source.
Sir, again, you're one of the authors.
Correct.
Of the GCTA
That's
law.
right.
So far, your thoughts on how it's been implemented so far?
Our bill, which became part of the law on the Republic Act 10592, clearly provides that the provisions of this act, meaning the Good Conduct Time Allowance Act, will not include what are these prisoners who are not involved, who will not be given the time allowance. First in the list is recidivists. Who are recidivists? Recidivists are those who, while in prison, commits another crime. He's a recidivist. Number two, habitual delinquents. They don't follow rules of the prison. Magulo sila. They always are unruly and don't follow the rules of the prison rules. Third, escapees. Those who escape are not, of course, of good behavior. And very importantly, fourth is that those charged with heinous crimes should never be included in the grant of this GCTA.
So considering recent developments, sir, what would you say about kung paano sinusunod yung batas?
There is a gross violation by the Bureau of Correction officials in granting and releasing those charged with heinous crimes. And that is why they have to answer, because our law also provides that if you violate the provisions of this law, for example, by granting time allowance to those charged with heinous crimes, they are going to be charged and they will have a 1-year imprisonment, 100,000 fine, and perpetual disqualification from holding public office. So these are things that should have been, the Bucor officials should have read the law and carefully scrutinize it and make sure that those charged with heinous crimes should not be included in the release of prisoners.
Okay. So did you see this happening, sir?
No,
when
we
the law
didn't.
was being drafted?
No, we did not.
Tama lang ba yung batas? Or now do you see that there could have been flaws? The
law to me is very, very clear, except that probably it should not have stopped under our law. It should not, the vetting process of applicants and the examination of their conduct should not only be left with the Bureau of Corrections, but we should have added a new tier of vetting, and that would be the Office of the Secretary of Justice. After all, the Bureau of Corrections is under the Department of Justice. And in other words, the Bureau of Correction will just be recommendatory to the Department of Justice. And also from that, it should be sent to the Office of the President. After all, the Office of the President grants the pardon and parole. So why not in the grant of release for good conduct time allowance?
Is this something you're going to push for
Yes.
now? Because the existing law does not
Correct.
include the DOJ,
Does
does
not.
not specify the
Yeah.
Office of the President. That's something you
That's
will
something.
propose now?
The other thing that we probably would look into is the fact that the Senate, in their version, which became the law, increased the days of the good conduct time allowance. For example, the first 2 years, the prisoner will be given, instead of 8 under the revised penal code, 8 days, it becomes 20 days. If you go further to the 10th to 11th year, every month of service, if you have good behavior, you'll be given 30 days. Practically, wala ka ng prison term for that particular 10th year to 12 years, because every month that you are in good behavior, you will be given 30 days. So that is something that we will look into. The Committee on Justice of the House under our chairman, former Justice Ching Veloso, will have a hearing on Tuesday after the Senate today.
Sir, more than 22,000 convicts released
Wow.
since 2014, almost 2,000 of whom convicted for heinous crimes. Now, you want their names released
Yes.
by Bucor, but it hasn't done so, saying that the law also does not require them. Hindi daw po nila kailangan
At the same
i-publicize yun,
time,
that
at the
only
same,
a court.
yeah, the same vein,
can do
no, it does not say so. Precisely, the law does not have a confidentiality provisions, meaning that it is confidential for the prisoners to apply, that they will not be, their names will not be divulged, or after the release, that their names cannot be published. That is precisely not the intention of the law. The law is always believes on transparency. And in fact, at the time of application, they should already be published so that those who have information or evidence that they did not have good conduct can raise an opposition in the Bureau of Correction. Or after they are released, they should also be published to warn everyone, especially the aggrieved, the victim's family. And secondly, the community, that here is a convict of heinous crime already released. So it is the Bureau of Correction is duty bound to release this, because there's no prohibition for them not to release.
Okay, but they're saying, sir, that only a court order
that is not
will
so.
make them
No need for the
release it.
court. Under our system of transparency and the fact that we want to have the community know, they should release that as soon as possible. Those who have been released and those who are now applying, that should be the case. There is no prohibition in the law that they cannot be published, or any confidentiality provision that their names should not be given out to the public.
Would you say then, sir, that there seems to be a lack of transparency in the law? Because, you know, the Integrated Bar of the Philippines, it's recommending na dapat daw i-upload sa website.
That's correct.
But in the existing law, sir, meron bang such
There is none,
mechanism?
but that is given. That, you know, when you have an application for a grant of good conduct time allowance based on their good behavior, then it should be brought out to the public, because good behavior is something that for example, the families of the victims can go to the Bureau of Correction and say, oh, this, for example, Sanchez, 1.2 million worth of shabu were found.
Even yung records, sir,
Yes.
nung convicts inside. Ano?
Yes, yeah. So therefore, these are things that if the Bucor are blind and they could not see that, then it should be the public and the families who will be able to bring that out. There should be an uploading, and there should be a publication of applicants and also those already released by the Bureau of Corrections.
But sir, you yourself just mentioned daw na hindi siya yata specified talaga
No, but
sa
not
batas.
specified. But the rules of transparency, the rule of due process, the rule of due process in the Constitution. What is due process? Give a chance to the victims of this convicted felons to be able to say, oh, don't release him because we have evidence that he is one of the charged in heinous crimes. He's a recidivist. is a habitual delinquent, and so forth and so on.
Okay. As you mentioned also earlier, sir, the Justice Department is saying na malinaw that excluded dapat yung mga convicts charged with heinous crimes.
Right.
But some DOJ officials are saying this is not reflected in the implementing rules and regulations of the law. Can that happen? Paano ba yun?
That should not be. If it is not in the implementing rules, the law still prevails over the implementing rules. And the law that we made, the one that we crafted in the House, is became law. I am one of the authors. It's clear that these are the four people, prisoners, who cannot be given this time allowance, and especially heinous crimes. And the reason for that is, they have inflicted so much grave offense against society. That's why the case is called People of the Philippines versus Sanchez, for example. Because what is aggrieved is not only those whom he kidnapped, as convicted, kidnapped, murdered, raped, and murdered, but, of course, the family should always be considered. Yes.
Okay, we'll talk more about the GCTA law after we take a short break. This is The Source on CNN Philippines. Please stay tuned. You're watching The Source on CNN Philippines. Our guest today, House Committee Chairman on Constitutional Amendments, Cagayan de Oro 2nd District Representative Rufus Rodriguez. We're still talking about the GCTA law. Now, sabi nyo, no, sir, in response to the DOJ saying that the IRR is not very clear on yung exclusion for heinous crime convicts. Now, pending possible amendments doon sa law, could the IRR then be amended for now? Would that be a quicker
Yes,
response?
it could be amended, but it will also take time because they have to study the amendments and have to be published. So therefore, but I agree with the Secretary of Justice that meantime, that they are considering this. He has, the Secretary of Justice has supervisory powers over the Bucor. And therefore, he can order that we prevent yet the release of even those signed already. That's the power of the Secretary of Justice. So we hope that the review will be fast. They have 10 days that they said they will come out with a study and come out with the new amendments to the IRR and then be able to therefore have them published immediately.
Okay. In some earlier reports, sir, you were quoted as saying that kung nasunod yung version ng House, there would not be as much confusion right now about the law. Is that right? Can you tell us more about that?
Yes, because, our bill was really just be able to include those under preventive imprisonment. In other words, those who have been arrested. Not yet convicted, but in prison. Now, our justice system takes time for the hearing to be finished. And so it takes them 3 to 5 years. So in that particular case, our bill was to include those under preventive detention. So they will also get the benefits of the good conduct allowance. Because in the revised penal code, only the convicts, those already convicted with final judgment. So but in the Senate, they were the ones who added days, no? From 8 days to 20 days, from 10 days to 23 days, until 15 days, naging 30 days. So practically, so that's the version of the Senate which became law. And so there's a little confusion there because our bill had that particular provision on excluding the heinous crimes, but in the second section it was not there. But our bill was very clear, which became law. Coverage of this act, the entire act. So therefore, reasoning would show that if even those only preventively detained, you cannot include in the good conduct time allowance those who are charged of heinous crimes. How much more for those who have already been convicted under Section 2? So to me, the law is very, very clear. That
Hindi niyo naman sinasabi, sir, that the Senate's version back then sort of made the law, yun nga.
They increased the days. The Senate increased the days to in the 10th year to only 15 days to 30 days. In other words, practically on your 10th year of detention, practically if you do good conduct, you are credited almost the entire month. So ganun.
Okay. Now, sir, apparently even convicted Chinese drug lords have benefited from the law release orders issued for at least 4 of them who are now waiting to be deported. Now, mukhang sinuspend muna, sir,
Yes.
yung pag-deport. But to begin with, paano kaya nakalusot ito? What would you...
Precisely. these are, these are part of big-time syndicates on drug trafficking, and they had been released. If there is a heinous crime offender, this is the clear case, because drugs is one of those mentioned in our law on heinous crimes. First is rape, murder, then drugs, and then robbery with violence, intimidation, and then destructive arson, and then we have also this kidnapping with illegal detention. So clearly, drugs is one of the main heinous crimes our country wants to really fight. And that is why we are really surprised, and we're very sad that these Chinese nationals who are the source of drugs, who were convicted for drug trafficking, have been released. And we all know that when these people were in the jail, they continued their trade through cell phones, through contacts outside. Now, they are now released. So these are exactly the case of heinous crimes, and they should have not been released by the Bureau of Corrections.
Okay, right now we're showing a breakdown of the release per heinous crime. So
Imagine that,
marami
murder.
talaga, sir.
Yes, and rape.
Now, Malacanang is saying na dapat ibalik those who have already been released. Ibalik sila sa prison, but the DOJ secretary is saying it's not that simple. So paano ba yun? Is that possible?
No more, because Article 99 of the Revised Penal Code, which is also part of the amendment to what we have passed in Republic Act 10592, Article 99, it says, such allowance, when granted, shall not be revoked. So, kung nag-grant na yung allowance and they're released, how can we re-arrest them? So, I disagree with the palace that we can just arrest again those 2,000 heinous crimes offenders and bring them back to jail. No,
Right.
you can only arrest them. There's a warrant of arrest for a new crime committed.
Okay, this is Article
Yeah.
99 referring to that,
That's correct.
what you were
You see the
just
last
saying.
sentence, yes.
But the presidential spokesman also said that that provision only assumes regularity in the release order. Kumbaga, kung nagkamali doon sa pag-apply ng batas, hindi daw maa-apply itong yung bawal ibalik.
The law is very clear. Once you have granted it, it cannot be revoked. And so what will be the basis for you to
Yes.
arrest them? Who will be the judge who will issue a warrant of arrest when there is no new case? So really, it cannot be done. So any lawyer, law student will know that you cannot make an arrest based on a wrongful appreciation of the Republic Act 10592. It cannot be done. There has to be arrest is by a judge who determines probable cause for issuing a warrant of
Wala nang
arrest.
bawian.
There's no more case. Wala nang bawian doon. Then one thing here that has happened is that those not yet released, the Secretary of Justice rightly has stopped the release, and that is correct. But those released, no more. So these Chinese who have been
Yes,
detained,
paano po yung sa kaso ng
they
mga
will have to be
Chinese?
deported. That is the law. After
Even if
service of
it's been
sentence.
suspended now
Yes,
to review?
that's not really, unless a new case will be filed against them, we have, that is not what it is. That's what the law says. You grant, if the Bucor officials were wrong, then they are administratively and they will be criminally liable. But the effect is effective once you have released the person.
Okay, well, some lawmakers, sir, are implying that baka daw may kumita.
Well,
What do you think about that?
From the fact that since 2013-14 and up to now, so many of the prisoners, including heinous crimes offenders, have been released, then we have really that ground, we have a ground to suspect that money changed hands in this particular granting of these petitions. And why the secrecy? Why not, be transparent and have this, uploaded and printed applicants, so that the families and those of the community can come out and be able to comment on the application. And then why also not release? The convicts, pardons, the pardons given to the president are published. They're also given out. There is no confidentiality there.
Okay, we'll be taking another short break. This is The Source on CNN Philippines. Please stay tuned. You're watching The Source on CNN Philippines. Our guest today, House Committee Chairman on Constitutional Amendments, Cagayan de Oro 2nd District Representative Rufus Rodriguez. Sir, of course, today's a big day about this law, the GCTA law. The Senate will be having an investigation starting this morning. What are your expectations from this program?
I would expect first the head of the Bucor to attend.
Yes, he
could not
will be there. He will
it's
be
a big
there.
issue, and he is the person mentioned in the law who would grant time allowances. The director of the Bureau of Corrections, that is one of the sections of the law, he should be there, and he should be able to explain exactly why they included heinous crimes offenders in the law. And I would expect also the senators to grill him and to point out that they should not have been granted.
Now, Mr. Faeldon earlier denied that there were plans to release former Calauan Mayor, rape slay convict Antonio Sanchez. And yet, in the past few days, may nagcirculate a release order actually signed by him.
Yeah.
What do you make of that then?
Well, that's it. That he will be one of those very much responsible if he signed the release of former Mayor Sanchez. Clearly shows that he himself violated the law, because the law, heinous crimes should not be given to persons charged with and convicted with kidnapping, rape, and murder, like Mayor Sanchez. Yes.
Well, his camp is saying that the Bucor chief signed it upon the recommendation of a committee. Paano ba yun, sir? Ultimate responsibility
that is never
is
a
up
defense that you just depend on your subordinates to make the recommendation. You yourself, who is going to sign this, because under our law, the Director of Bureau of Corrections signs this, and for those for jails, provincial, city, district jails, it will be the jail warden or the BJMP. But in this case of the Bureau of Corrections, it has to be, we have Director Faeldon. And so therefore, he could not in any way be able to exculpate himself there. You cannot say, it's my subordinate. The buck stops with him. He has to examine those who are applicants, and he should know, being the director, that heinous crimes offenders are not included in the time allowance that you give to these people.
Some lawmakers saying the president should fire him or let him go. Should he resign? What do you think?
Well, I think everybody in this country would also require due process. Now, precisely, there is a hearing, and in fact, he has to answer to the president. He has to explain to the office of the president. So we are not very hasty in calling for resignations of Faeldon and the others who have examined this and recommended this. What we're saying is that they should be made to answer administratively. That's in the law. They should be able, we should give them due process. Let them give their defenses after due notice and hearing in administrative cases. That's the time to dismiss him. And also for the criminal aspect, let a case be filed, and then they will have to make an answer. This is what due process is all about. So I'm not going to call for any resignation without hearing their case in writing and under oath. That is always the law.
Apart from the Bucor chief, sir, who else could be held responsible? Kumbaga, pati ba yung mga recommending
Of course,
officials?
the ones who
also?
evaluated the entire process, those who were involved in the entire process, because from the very beginning, those who accepted the application and then the people that will evaluate these applications are clearly in conflict with the provisions of the law and violates the law on the GCTA.
And tomorrow, sir, the House of Representatives will also be having an investigation on the GCTA
That's
law.
correct.
Nag-confirm na po ba si Mr. Faeldon
I have
that
to
he will
check
also
now.
be
I haven't been to the office yet, but we'll check with the committee. I'm sure that the subpoena had been issued to, of course, Director Faeldon. He is the top man in the Bureau of Correction. We'll check. But again, we appeal to him to appear in this committee and be able to give his side, so that we will not make into also hasty conclusions without hearing his side. So therefore, let us hear the side of Bucor Chief Faeldon. I hope she comes. I'm the senior vice chairman of the Committee on Justice.
A subpoena, sir, has already been issued,
Yes,
right?
it has been issued to the Bucor chief, and we'll see him tomorrow in the Committee on Justice, chaired by former Justice of the Court of Appeals, Ching Veloso.
Okay, now Senator Win Gatchalian, sir, is saying dapat i-abolish na lang daw yung GCTA. What do you think about
We
that?
don't agree. That's another, gun from the hip, So we don't do that, We are legislators. You just say, just take it out. No.
Let me read his tweet first. Sabi niya, let's simplify our lives. Just abolish that GCTA para wala ng korupsyon at mga lagay-lagay sa loob ng Bucor.
Well, I don't agree with that. A house has some problems. You don't burn the house. So therefore, in this case, what should be, we should, this good conduct time allowance has been there because if you go to the concept of our criminal system, our penal system believes in reformation, rehabilitative, not retributive, not punishment. So therefore, we are saying that we are trying to also, people with good behavior, they are not in the heinous crimes category, they are not escapees, they are not habitual delinquents, they are not recidivists, has the chance to reform their lives and to be able to go back to society. That's why this has been a 1930 vintage of our revised penal code of 1930. And the revised penal code of the Philippines comes from the Código Penal of Spain because we were under Spain of 1889. So these are all from tradition. Good behavior of prisoners are always rewarded. And that is why we say that we will not burn this down, we will not cancel them. It is also good for society that we are able to reform them, give them a chance. Then we will therefore just amend the law. So probably, yes, make sure that never will there be an interpretation that heinous crimes are not included in this GCTA. Our access, it's covered by this act, the entire act. And then secondly, there should be more two vetting processes. From the Bucor, you go to Secretary of Justice, Secretary of Justice recommendation to the President, Office of the President. And then the number of days, we should not give already 30 days. So that's so much already given to them. So practically, hindi na sila magsiserve ng sentence. So from the 30 days maximum, baka pwede natin ilagay sa 15 days. But we have to give them good conduct time allowance.
Okay, last question, sir, and briefly, dahil mawawala na po tayo ng oras. Now, pending all these amendments, while we address, while congressmen or lawmakers address these issues that you're talking about, how then do we implement the law? Kasi, amendments yet to be made.
It will be handled first by
Suspend
the Secretary of
dapat
Justice.
muna.
Yeah. Secretary of Justice has already with the Secretary of Interior, they are now studying what will be the IIR. It will be cured by the IRR, some of them. Then the IR will cure it, but there's still a need for Congress. So meantime, the point is, the Bucor should not anymore process those who are excluded by the Act, especially heinous crimes. And then that is what we recommend.
Thank you very much, sir. Thank you, Cagayan de Oro 2nd District Representative Rufus Rodriguez. Thank you for joining us here on The Source. I'm Ina Andalong. You're watching CNN Philippines.